Welcome to Breaking History, the Supreme Court Historical Society show where we highlight modern scholarship about the Supreme Court's endlessly interesting past. I am Clare Cushman, and I'm here with Ross Davies. He is the editor of the Journal of Supreme Court History, a law professor at George Mason University, and has written an astonishingly wide range of topics on legal history. But today, we are going to discuss his new article in the Journal of Supreme Court History titled, "With a Little Help, but Not Quite Enough from 9 Friends, the Appointment and Disappointment of the Official Reporter of Decisions for the U.S. Circuit Courts of Appeals." A piece about how lower court opinions got reported and published in the 19th century might not seem like a riveting read, but it is. So first, Ross, I need to ask you, why is court reporting a topic that we should be interested in at all? What is the job of a court reporter? It seems like a judge writes the opinion and then it gets published, goes to the printer, but there must be more to it. Tell us about that.
Thanks, Claire. Perhaps the best way to think about this is to go back to our childhood. At some point when you were in elementary school, you surely played a game called telephone or something like that, where the first child says something to someone next to them, and that child then says it to the next person, and that child says it to the next person. And by the time the message goes around the circle, it's gobbledygook. What the reporter of decisions for any court is responsible for doing is making sure that what the judge said is exactly what appears in print, and that it appears in print in a way that maximizes the chances that no telephone game will be not played, but sort of unfortunately happen with the work of the judge down the road. So what a reporter does essentially is take what that judge or that court chooses as the words for a decision and make sure that they are put on paper in exactly the right way. And that has all sorts of facets that we might not normally think about, from cite checking to make sure that when there's a citation, it's to the right case or statute or what have you. And also just so extremely fly-specking proofreading, making sure that every single word, letter, number, spelling, punctuation is exactly the way it ought to be. And then, even once all of that's done, the reporter of decisions, historically and to a large extent to this day, is responsible for basically being sort of the executive publisher, for picking the right entities, the right businesses or people to put these books in print, to make sure that the pages are collated and bound properly, that they're distributed properly, and all of that. And nowadays, of course, it also includes being a high-tech publisher, making sure it's all done properly on the internet as well, and making sure that all these different versions are consistent. And then 100 years from now, when someone does find a mistake that was in something printed 100 years ago, making sure that that gets taken account of properly as well. So it may seem like a simple matter of being a stenographer, but there's a lot more to it than that.
So let's go back to the 1800s. What was the situation in the lower courts in terms of court reporting?
It was very much a cottage industry. Every court tended to have their own reporter, and for many of these courts that were in relatively impoverished or thinly populated communities, there wasn't enough of a market for the opinions that a reporter might produce to make it financially viable to even have reporting as we think of it today. A lot of reported decisions were reported only in the sense that they appeared in a local newspaper or in a pamphlet published by one of the parties or one of the lawyers. Now, in bigger or more populous or more prosperous jurisdictions, like, say, New York City or Baltimore, or Boston, it might often did look more like what we see today. Plump books coming out once every few weeks or months or what have you. But it was quite varied and was at least until 1880 or so, in all cases, done court by court or jurisdiction by jurisdiction.
And often it was the judge himself who reported on his own opinions. Is that true?
Yes, you're correct. That is often the case. Who is going to make sure that this gets done properly?
Mhm.
Who is a lawyer who understands how these things are done and what quality looks like? Yes, in a lot of instances, it would be the judge themselves or someone in their their inner circle, someone they could trust to do this right. Uh,
Mhm.
so if it wasn't the judge, it might well be the judge's professional protege or the judge's son. In those days, it was never a daughter, but yes, it was often. I would hesitate to say always, but pretty darn close to always, either the judge or one of their closest
Mm.
associates.
But then entrepreneurs also got involved and they took on this job to make money. So they were both editors, but they also had to market these volumes. So these are two different skill sets. I mean, proofreading, site checking, all of that, plus getting people to actually buy these volumes. Talk about that.
You are 100% correct. They are different skills, they are different passions, and it is rare for them to appear in the same place. And so we tended to get either people who were, it's not fair to say that they were not careful, but it was not their thing to be reporter caliber careful about the text, right? But they might be pretty good at marketing. Uh, and so you get some jurisdictions where you have not the finest reporting being done, but it is appearing frequently, it's appearing affordably, and so on and so forth. But then you get the people who, and some of these are names we still know today, who were quite, by and large, quite good at getting things just right, right? William Cranch, for example, who reported the decisions of the Supreme Court in the early 1800s, he was quite good, all things considered, at getting things just right. But people at the time assumed that he was not in a hurry because these things took a long time to come out. Uh, and what goes along with not getting your product out on time? Slow sales. And so there is, correspondence still exists about early reporters who were quite good at putting out stuff we still use, complaining about how it was bankrupting them. So
So tell us about the Supreme Court justices. Did they, I mean, was a hodgepodge situation. So did they fight to get reporters for lower courts? I mean, especially because the justices were sitting on circuit. So they must have noticed that there was a dearth of quality reporters covering their opinions.
oh yes, as we know, in fact, for the first 100 years or so, or actually, I guess technically almost 150 years, the Supreme Court justices were also lower court judges. They sat on circuit. Uh, and one would like to think that they would be concerned about this, and one would be wrong. Uh, they were, some of them were pretty good about making sure their own opinions on circuit or the opinions of their own circuit courts got published. Nathan Clifford, Joseph Story were two of the best about that. But although they were aware of this problem, they didn't do anything about it.
So enter John West, the founder of West Publishing. And he was 1880, he launches the Federal Reporter to report on lower court decisions nationwide. Um, Tell us about the advent of West coming into this, and was the Federal Reporter a success?
Uh, yes, absolutely. And basically, John West, uh, who came from who started in what was still at that time sort of the Wild West. He was from Minnesota, right? This is the whole Eagan, Minnesota as the source of all law in America, because there was this unbelievably energetic and visionary. Basically, he started out as a stationery salesman, and he just got into publishing Minnesota reports and saying, "Hey, this is good, and there's a market for this." And he gradually branched out and developed all the or nearly all the state and regional reporters nationwide for state courts. Uh, and he was doing this again in the 1870s at the very time that national law in the post-Civil War era was becoming a bigger part of Americans' daily lives. And so it was logical, it was natural, as he was conquering the world of state reporting, to branch out into the feds. And so West Publishing started in 1880 this thing called the Federal Reporter that reported all those things that the justices weren't helping the lower court judges get published. And it was unbelievably successful. It was pretty much adopted nationwide. And one example of how successful it was is that when one of those entrepreneurial sort of local, court reporters announced they were going out of business, in the publisher's note at the beginning, they explained why. And it was that West was eating their business alive.
So every time we search for an opinion on Westlaw, we should say a little thank you to John West for having gotten it started as early as he did. So now your story gets really interesting. We get introduced to Samuel M. Blatchford, who served on the Supreme Court from 1882 to 1893. Notice how I emphasize the M in his name. That will become important later. So who was Samuel Blatchford, and what is his connection to opinion reporting?
Oh my gosh, Samuel Blatchford. Samuel Blatchford was he was the son of the founder of what is arguably the most historically significant law firm in U.S. history. It's now known as Cravath, Swaine and Moore. It was started in 18, views are slightly different about this, but 1818 or 1819, and has been in business, under one name or another ever since. And Blatchford was one of the best lawyers ever to practice in that firm. And in his spare time, when he wasn't being one of the best lawyers in one of the most important firms in America, he was the only reporter of decisions who successfully competed with West. So he was phenomenal in both of those respects. And he was widely recognized, for his practice skills and also for his reporting skills. At one point, the State Department hired him to put out a report of decisions related to basically foreign affairs kind of things. And then in 1867, he becomes a district court judge. And then he becomes a circuit court judge. Sorry.
No, so was he being paid, or was he an entrepreneur? What
He was an entrepreneur. So even when he was working for the State Department, he was working under a government contract. So he was doing these things, yes, with the support of the judges whose opinions he was reporting, but he was running this business. He did other publishing as well that we don't need to get into. But he was just phenomenally good and phenomenally energetic. And he was, back to your earlier question, he was someone who was really, really good at reporting and really, really good at the business end as well.
Definitely an underrated Supreme Court justice. So we're delighted to have him on the show today. In 1891, Congress passes the Evarts Act, which of course creates the courts of appeals. Was money also appropriated to pay for court reporters to cover those courts?
No. Congress was still not looking out for all those helpless lower courts and their decisions. They were still on their own. I do suspect, though, that Congress was well aware that West was in this business now, and they may have thought, we'll just let West do it.
But Justice Blatchford had another idea about how to cover these courts of appeals. Tell us what his idea was.
Sure. So what happened was, of course, West was not the only law publisher around. And in fact, the publisher of Supreme Court opinions at the time was a company called Banks Publishing. And Banks saw the Evarts Act, which created these new circuit courts of appeals, as an opportunity to get a foot in the door with publishing Court of Appeals opinions, with competing with West. So they approached the reporter of decisions for the Supreme Court, a guy named J.C. Bancroft Davis, and say, hey, would you report, would you take on being the, sort of a reporter of Court of Appeals decisions, these circuit courts as well? And Davis says, no, I don't have time. And then somehow, for some reason that we can't be perfectly sure of, Davis says, but I know someone who could do a good job. A man named Samuel A. Blatchford. Samuel A. Blatchford was the son of the great Samuel M. Blatchford. Go ahead. Sorry.
who is who is now sitting on the Supreme Court. And
Yes.
so this could be a story about a Nepo baby, which is a hot topic in today's world, but it's not really nepotism. I have to say that I love the part of your article with all the letters back and forth about the, I wouldn't say higher appointing of Blatchford feasts. Um, so just because nepotism is such an important part of this story, can you just clarify again how much Justice Blatchford put his thumb on the scale? It seems like he didn't really, pull strings for his son, but he had the idea for his son to get this appointment. Can you just clarify that a bit?
Yeah, that actually what you touch on there is sort of the first of all, it does well, of course, being Samuel A. Blatchford surely helped his son get this. Samuel
Mhm,
M. did not campaign for this. It's
mhm,
not clear whether the idea for Samuel A. came from the Supreme Court reporter of decisions,
mhm.
J.C.
Thank God.
Bancroft Davis,
Mhm,
or from Samuel M. Blatchford. But what we do know is that Davis sort of nominated Blatchford the son, Samuel A., told Banks, this is a guy you should talk to. Uh, and Samuel A. then talked to his father about it. And his father didn't say, no, you shouldn't do it. Uh, and then the letters to which you refer basically fall into two categories. One is Samuel M., the father, corresponding with the Chief Justice, Melville W. Fuller, saying, this is up to the rest of you guys. This is an 8 justice decision, not a 9 justice decision. And he's pretty clear about it. Of course, he could have said, no, you really shouldn't do this. This will look bad or what have you. He didn't do any of that, right? So he wasn't, undermining his son's candidacy for this, but he was definitely within the correspondence, within the court. He was making it clear that this is up to you guys. And he does not say the words, you will not hurt my feelings if you go another way. But it is there between the lines. He wants his colleagues to do the right thing, and he trusts them to do the right thing.
got it. Okay, so Samuel A. So he was not hired as the reporter for the lower courts. He was sort of designated as an official reporter. So did that give him a leg up over West Publishing? I mean, how did the staff at these courts of appeal treat Blatchford versus somebody from West?
Uh, we don't have all of the details because we don't know everything that happened with West. One of the great
Mhm,
tragedies about West that people who do this
mhm,
know about is
mhm.
that most of their records are gone. Uh,
Okay.
but what we do know is that, or can be pretty confident of, is that West handled these new courts the same way it handled all of them. It sent one of its own people to the court every time the court was sitting to make sure they gathered everything. So odds are West just,
Mhm,
for
mhm,
the circuit court that's sitting in San Francisco, the
mhm,
Ninth Circuit, they send their
mhm,
California person there to get the stuff. What
mhm,
Samuel A. does get is
mhm.
a standing order for each of what were then the 9 circuit courts, instructing the staff, the marshal or the clerk of the court, to send a copy of everything to Samuel A. in New York. So Samuel A., unlike West, does not need to build a network of agents to be doing this work for him nationwide. It just all comes to him at his office in New York.
Oh, I see. That is a leg up. Yeah.
It's a little bit of a leg up.
Yeah.
But
So,
but but West was well positioned to compete.
right, right. Well, and what we'll see next is that they succeeded in beating him. So Justice Blatchford, he dies in 1893, and young Blatchford's publisher of what was called what was it, U.S. Appeals? That was the name of Blatchford's
Mhm.
series,
Yes.
court reporting series. So the publisher, you referred to the name earlier. Can you remind me?
Sure, it's Banks.
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 Banks tells him that he needs to get a federal subsidy to stem the losses because U.S. Appeals is not making money, or I should say losing money to West. I don't really. So then Blatchford writes directly to Chief Justice Fuller in 1899 asking the Supreme Court to lobby Congress for funds to give him that subsidy so he can continue his work. The I have to say the back and forth thing of all the letters that you feature in this article are such a great read, and it's such a treat. And I'm going to ask you about those after you answer this question, though. So, first of all, talk about this demand for Fuller to step in and ask Congress for the funds.
The word for this, I think, is chutzpah.
Yeah.
The first time I read this letter, sitting in the Library of Congress, laughing out loud. This is this fella who is, I mean, he's not young,
Hmm.
so it's not like he hasn't seen how business works and so on.
Hmm.
And
Hmm.
basically, it's a letter to the Chief Justice of the United States saying,
Hmm.
"Go to Congress and get me some money." Uh,
Hmm.
and he goes through, and for historical purposes, it's a wonderful letter because he goes through the finances of the U.S. appeals reports and explains, that you know we're having trouble selling these things. We've never sold a lot, and the sales are dropping quickly, and it's all West's fault. And on top of that, Banks is splitting into two businesses because the brothers who have inherited the company can't get along. And I've been assigned to uh, basically the brother I don't want to work with, and the brother I don't want to work with is not going to subsidize this. And it's on and on and on and on about this. And one of the things, by the way, that is not in that letter, this is just a sort of a bonus tidbit from what's in the article, is that Samuel A. Blatchford, Samuel the son, had basically been kicked out of the family law firm that his father had been part of building up over the years because he just wasn't that good of a lawyer. Uh, but when he got in his fight with the Banks Publishing Company about keeping his U.S. appeals alive, who did he hire to represent him? His old law firm, because he knew who the best lawyers were. He'd worked with them. So anyhow, we have this letter that he writes to Fuller making this brazen demand for lobbying support.
I have to go back to the letters. So
Sure.
how did you find these letters? Did you what tipped you off to where they would be was it in the Fuller papers that you found them? And how did you no, not the Fuller paper. Where were they? How did you
Well,
find them?
they were in two papers. They were in the Fuller papers, and they were in the papers of J.C. Bancroft Davis, uh, who was, in addition to being reporter of decisions for many years, which was and remains today a historically significant role. He
Mhm.
also was a judge himself. He was involved in foreign affairs, and his papers are at the Library of Congress. And
Mhm.
no matter how well cataloged, and our library tends to be great about cataloging things, no matter how
Mhm.
well cataloged things are,
Mhm.
sometimes you just don't know what's there until you go look at it. And so you know how this is, right? Just you go and you graze, right?
It's a great find. It's a fantastic find. So moving on, we the so basically Blatchford's enterprise shuts down in 1899. Uh, was it a failure? What is its lasting legacy? Did it provide anything different than what other companies West Publishing were providing?
It was a commercial failure, and uh, historically speaking, it is almost a substantive complete failure. Nobody cites it.
Hmm.
Almost no one. There are almost no hard copies of these books left in existence. They are online. Harvard has digitized them, so if you want to look, you can. And sort of a follow-on project that I've started working on with this is to go through and try to do a reasonably good comparison to see whether there is anything that's in the Bancroft volumes, of which there are 63, that isn't in the West reporters Federal Reporter from that time. That project isn't done yet. The one thing that is in the Samuel A. Blatchford volumes that is not in the Federal Reporter is all the procedural stuff from the launch of those courts of appeals in 1891 and 92. So all the initial orders, the initial staffing, and so on and so forth, that's in the front of some of the early volumes of those books. So that at least is worth holding on to.
Well, thank you, Ross. This has been fascinating. Please look for Ross Davies' article in the Journal of Supreme Court History, which you can subscribe to by going to supremecourthistory.org. And stay tuned for more in our series of Breaking History.